Welcome to the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. I'm Deepa Taylor, and today we're diving into a topic that's highly relevant for many couples across Ontario: legal considerations in common law separations. If you're in a common law relationship or considering entering one, this episode is essential listening. Let's start with the basics. What exactly is a common law relationship? In Ontario, a common law relationship is defined under the Family Law Act as a couple living together in a conjugal relationship for at least 3 years, or for a shorter period if they have a child together and are living in a relationship of some permanence. Unlike marriage, common law relationships don't require a formal ceremony or legal documentation to establish, but they come with their own set of legal considerations. One of the biggest misconceptions is that common law relationships and marriages are treated the same in the eyes of the law, but that's not entirely true. While there are similarities, especially when it comes to issues like child support and spousal support, there are significant differences, particularly regarding property rights and the division of assets. Unlike married couples, common law partners do not have automatic rights to property division under the Family Law Act. When married couples separate, there's a process called equalization, where the value of property acquired during the marriage is divided equally. However, this does not apply to common law couples. For common law partners, property rights are more complex and often involve making trust claims. If you and your partner bought property together and are both on the title, then you share the property equally. But if only one partner is on the title, the other partner may have to make a claim under what's known as a constructive or resulting trust to prove they have a right to a portion of the property. A constructive trust can be established if the partner not on title can prove they contributed to the property in a meaningful way, whether through financial contributions or significant labor, such as renovations or upkeep. The key here is demonstrating that their contributions enrich the partner on the title and that it would be unfair for them not to share in the value of the property. When it comes to spousal support, common law partners have similar rights to those who are married, but only if they meet certain criteria. To be eligible for spousal support in Ontario, common law partners must have lived together for at least 3 years, or have a child together and have lived together in a relationship of some permanence. Spousal support is not automatically granted. It's based on need and the financial disparity between the partners. The spousal support advisory guidelines are often used as a starting point to determine the amount and duration of support. These guidelines consider factors such as the length of the relationship, the roles each partner played, and the financial contributions each made. A unique aspect in Ontario law is the Rule of 65, which applies to both married and common law couples. If the years of cohabitation plus the age of the support recipient add up to 65 or more, indefinite support may be available. This is particularly relevant for older spouses who might have sacrificed career opportunities to support their partner or raise children and now face financial difficulties after separation. Now let's talk about parenting. The law treats parenting the same way for both common law and married couples. The recent changes to the Divorce Act replace the terms custody and access with parenting time and decision-making responsibility, which reflect the modern understanding that both parents should be involved in their children's lives, regardless of their relationship status. One of the critical factors in determining parenting arrangements after a separation is the status quo. Courts often favor maintaining the current living arrangements for the children to provide stability. However, this can be challenging if one parent wants to change the existing arrangement or increase their time with the child. It's also important to remember that parenting time and decision-making responsibilities are separate issues. Parenting time refers to the physical time spent with the child, while decision-making responsibility involves making important decisions about the child's life, such as education, healthcare, and extracurricular activities. Separating from a common law partner is different from a divorce because there's no legal process like a divorce decree. Many common law couples choose to resolve their issues outside of court through negotiation, mediation, or collaborative law. The goal is often to reach a separation agreement that covers issues like spousal support, child support, and the division of property. If an agreement cannot be reached, the case may go to court, where a judge will make decisions based on the evidence presented. It's worth noting that if you've already reached an agreement or obtained a court order in the past, but circumstances have changed, you can seek to amend the agreement or order through further negotiation or by returning to court. Finally, let's talk about limitation periods. In Ontario, the limitation period for making a property claim in a common law separation is generally 10 years from the date of separation, provided the claim involves real estate. For other types of claims, like those not involving real estate, the limitation period might be shorter, potentially 2 years, but this is more flexible and depends on the specifics of the case. If you're unsure about whether you can still make a claim, or if the limitation period has passed, it's crucial to consult with a family lawyer. Missing the limitation period could prevent you from pursuing your rightful share of property or support. As we've discussed today, common law separations involve many legal considerations that differ from those faced by married couples. Whether it's understanding your rights to property, spousal support, or parenting time, being informed is the first step towards protecting your interests. Thank you for joining me today on the Divorce Lawyers podcast. If you have any questions or need further assistance, don't hesitate to reach out to us at DivorceLawyers.ca. Stay tuned for our next episode, where we'll delve into another important topic in family and divorce law. Until then, take care and remember, you don't have to navigate this journey alone.